The question before the court is when a feature of a design of a useful article is protectable under the Copyright Act. Specifically, what the court is looking at is whether the graphic design elements of the cheerleading uniforms at issue are separable from the more utilitarian features of the uniforms themselves. Useful articles cannot be copyrighted, but the design elements of useful articles may be copyrighted if they can be separated from the useful article. The issue becomes most complicated when you're dealing with three-dimensional objects, where the actual physical characteristics of the object may have some functional utility to the object too. For instance, if you have a bike rack that is also a sculpture, the elements of the sculpture may be providing some functional features to the bike rack. And is it a sculpture or is it a bike rack? Varsity is saying this is really no different than those situations where someone takes a famous painting and applies it to a t-shirt or a canvas bag or a rug. And that what the court should do is simply look at the graphic designs that Varsity is registered with the Copyright Office and ignore the fact that those are being applied to a cheerleading uniform in this case. Star Athletica, on the other hand, is saying that this cheerleading uniform is not really a cheerleading uniform if it is separated from the graphic design elements. The graphic design elements convey something about the uniform and about the wearer of the uniform, and so the design itself is important to the nature of the product. So even if Varsity prevails here, at best, they're prevailing on the protection for the graphic design elements that are applied onto the uniform itself. And the uniform and the design of that uniform gains no protection, even in the case of a victory. Varsity, in this instance, could very well prevail on this issue of whether the graphic design that they're claiming protection for is separable and therefore eligible for copyright protection, but then lose on the merits of the case because the design itself is not very original. So I can have sympathy for people who look at a two-dimensional design of a cheerleading uniform that incorporates zigzags and chevrons and common elements like that and say, well, there's nothing particularly original here. How can somebody design a competing cheerleading uniform without using these elements? That's something that the district court should look at if the case is remanded back to the district court.